Thank you for joining us here for an MP webinar covering the Great Resignation, key steps to reduce employer liability. I'm Katie Kreider, marketing specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee life cycle. Some of those services include recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Eric Sarver. Eric is an employment business law attorney for small to mid-sized businesses who've been practicing law since 1999. Eric began his career at a couple of prominent small law firms between 1999 and 2001, and then founded his own firm, the Law Offices of Eric M. Sarver, in April of 2001, with a focus on employment, labor, and business law for employers, business owners, and for employees as well. Eric has been an invited guest speaker at a number of professional organizations over the years, from the NYSS CPA to the NYS Bronx Bar Association, HR Roundtable Group, the Practicing Law Institute Incubators and Co-worker Spaces, and many other arenas, and has been a guest on TV, radio, and video podcasts. Eric conceptualized and now runs a weekly live talk radio show, a video broadcast, Employment Law Today on Al Katie and I. Eric has been interviewed about employment law and business law matters by news publications and trade publications. Raised in Valley Stream, Long Island, New York, Eric graduated cum laude from Binghamton University and graduated with honors and an academic award from Hofstra University of Law. He enjoyed spending time with his wife and son in suburban New Jersey, along with music, playing guitar, creative writing, working out, and cycling. For over 20 years, the law offices of Eric M. Sarver has defended, counseled, and represented small and mid-sized businesses in matters of employment law, labor law, and business law, including compliance with employment laws and defending companies in federal and state courts from wage and hour lawsuits, discrimination claims, and the Department of Labor investigations and proceedings. The firm's business law practice includes business information and incorporation, partnerships, investor agreements, and contract drafting and commercial litigation. Their clients are spread across various industries, as well as technology, hospitality and entertainment, professional services, retail, finance, marketing and advertising, are just to name a few areas. For more information, please visit the law offices of Eric M. Sarver's website at www.sarver-law.com. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of today's webinar later, along with the slides. And with that, I'm going to hand the mic off to Eric.
Great. Kevin, thank you so much for that, Katie. Really want to thank you. I want to thank Samantha for inviting me to speak today, and very much want to thank Nate Spinetti for your tech help. I love complex things around employment labor law. The tech side of things is not my forte. So thank you all and to everyone out there in the audience today, it's very nice to be able to speak with you about an area that I'm very passionate about, that being employment law and business law. So I'll start with the disclaimer, right? No attorney worth their salt would not state that this training is intended for educational and informational purposes only. So the information and the materials that I'm offering, they're for general informational purposes only. And what I'm saying does not constitute legal advice and should not be considered legal advice. And what I'm talking with you all about today does not form an attorney-client relationship between my practice and you, the viewer. And nobody should rely on any of the information in this webinar as the basis for taking a specific legal action, since different businesses have unique facts and require an individualized decision-making process. So parties seeking advice may consult with me, Eric Sarver, or the law office Eric M. Sarver, or with knowledgeable legal counsel, and should consult with such legal counsel familiar with their particular circumstances. All right, so with that out of the way, let's get to the fun stuff here. The presentation topics, which would be an introduction to the main issues we're dealing with today, some of the problems and quandaries and solutions that I'm offering for you here with this webinar. So we're talking a lot about the Great Resignation, which is very much tied into the COVID-19 pandemic. And let's just start a little bit with about what that is and what it's about. So the Great Resignation, I'm sure many of you know, but if you don't, it's a trend that started in or around 2021, where workers have been voluntarily resigning from their jobs at record rates, in mass, as they say. And in April 2021, for example, as COVID-19 vaccination rates increased, we started to see evidence of over 4 million Americans quitting their jobs. And by June, that was an additional 4 million more who quit. And by September 2021, we were seeing numbers of 4.4 million people on average quitting their positions. And this is according to the Wall Street Journal, that the fact that the percentage of people who are leaving their jobs is higher now than it has been in 2 generations. So what are some possible causes of that? And this again relates to our legal topic. The causes for some of the people resigning in such large numbers include wage stagnation, an increasing rising cost of living, economic freedom provided by stimulus checks, and might I add, enhanced unemployment insurance was driving many to think, why am I going back to this job I don't like? I can collect unemployment and figure out my next steps. Well, we saw record numbers of pandemic burnout, emotional, psychological, physical, related to people's jobs and careers, and record job openings, which sounds funny when you have wage stagnation, but as more people were quitting, the openings gave people a false sense of security that, well, I can quit my job without a new job in its place. I'll find something. And of course, in line with that, we see more workplace flexibility. With the change to remote workforce, with a work from home environment, a lot of people know that if they quit their job in New York, they may get a full-time remote position in California or Alaska. They're not limited as much by geography. And of course, safety concerns due to the COVID-19 pandemic and job dissatisfaction have all been reasons people have given for resigning from their jobs. And those last 2 points about job dissatisfaction and safety concerns due to the COVID-19 pandemic, I will discuss as related to 3 of our subtopics today. So there are 3 issues that I'd like to speak with you all about this afternoon. One has to do with the Great Resignation as related to non-compete agreements, non-compete clauses. What are the basics? What are the trends we're seeing? Are the issues of enforceability coming up? And what are my recommendations for you as an employer? And the second issue, which we'll get to, has to do with the rise in unemployment insurance claims that are based on the theory of constructive discharge, how that looks for people as employers, why the Great Resignation and the pandemic were causing such heightened rates, and what we can do about the risk to you as an employer to stave off these type of claims. And then the third thing we'll get to has to do with discrimination claims being on the rise in light of people asking for their different disability-based accommodation requests for their jobs under COVID, and some of the implicit bias we're seeing come out more that's being shared about on social media in articles that talk about implicit bias and the Great Resignation. So we got 3 issues there. We got legal quandaries, non-competes, unemployment insurance claims, and discrimination. So getting to the non-competes, the basics, right? So many might know a non-compete or non-competition agreement is a contract. It could be a standalone agreement or part of an employment contract, which prohibits employees from working for a competitor or for opening or competing business, usually in the same scope of services for a certain geographic location very often. And it has to do with a period of time when the employee is working for your company and the time frame after they leave the job, whether by termination, by resignation, by mutual quitting, if that's possible. But that's actually what the non-compete is really about. And amid this mass exit and mobility from the Great Resignation, what we're finding is that a lot of employers have ramped up enforcement of non-compete agreements. They've been trying to enforce them in order to keep employees with them on the job. Meanwhile, as the employers are ramping up this enforcement of non-competes, hoping to, number one, stop resigning employees from competing with them, and number two, hoping to set an example for other employees to say, hey, if you're looking to quit so quickly, keep in mind, like, you would have a non-compete and it won't be so easy to go somewhere else. Well, what's happening is that along the lines with that trend, we're seeing many courts are reluctant to find non-compete agreements reasonable, and they're being held as unenforceable because of the economy, because of numbers of unemployment levels that have gone up and down in the last 2 years. So the courts are often reluctant, as I mentioned, to enforce a non-compete during economic hardship. And the way they see it is that during a time of particular hardship, the restriction on where the person can and can't work for themselves or getting a new job is just an undue burden on them financially. So we have this disconnect, right? We have more and more people quitting, more employers scratching their heads saying, geez, I keep losing people. I don't want to lose these good people. I'm going to enforce the non-competes. And the court's saying, no, we don't want to enforce these. So we also have to look at the fact that during the Great Resignation, a non-compete could be not enforced for the reasons that existed before the Great Resignation, which is many people, many companies, their non-compete agreements were drafted too broadly. They cover an entire sector or industry, or the non-compete period is too long. And if you listening today have a non-compete that you have for your employees that's 4, 5, 6 years old, based on an old template, you ought to, I recommend respectfully revising those. Ideally, 6 to 9 months post-termination is a good, reasonable time frame for non-competes, or 12 months may be considered, but over that is often considered too long and struck down. And of course, the geographic scope might be something to consider when enforcing a non-compete, because many employees might have to move to get a job in their industry. So if the scope of the geography where they can't compete with you is too broad, that needing to move to work might be considered unreasonable and therefore unenforceable. And of course, the flip side of that, as I mentioned a moment ago, is that with remote work being so prevalent, you could counter that. The broad geographic scope is not unreasonable because people can find remote positions across the country. But I'm just trying to give you a general sense that there's a growing trend here of trying to enforce non-competes, and it's getting harder and harder to do so for various reasons. So here are some interesting questions that the courts will look at, which I'll talk about. And I say this because if you know what the courts are looking at when they examine non-competes that are being challenged, remember, many employees will challenge their employer and say, you can't enforce this non-compete. It's unreasonable. Or many employers will challenge an employee and say, hey, Joanne, I found out that when you quit last month, you went to work for the competition right across the street doing exactly what we do, using all of our secret sauce and our trade secrets, and that's just not acceptable. So what are the courts looking at? Well, they're looking at questions such as, is the employee getting anything in exchange for signing the non-compete? One way that you as an employer can make your non-competes more enforceable is to offer some kind of an added payment or consideration for that employee when they sign a non-compete. Perhaps they're getting a certain bonus or additional training, or you can actually have a non-compete where, let's say you want to go past 12 months for the non-compete, but you're worried that it'll be struck down. You can offer the employee, say, hey, after 12 months, we give you a 6-month payout for your full salary. And that way, the person can't argue it's too much of an economic hardship because they're getting paid as if they work for you. And you're keeping that person out of the circulation from competing against your company. Now, the question becomes, the courts have been looking askance at non-compete enforcement when it comes to a company that fired an employee. And you might say, no, the employee resigned. But what happens if they resigned claiming constructive discharge, right? Because constructive discharge, if proven, is basically a form of termination. And since the courts are looking more strictly at non-competes where the person was terminated, if the person was constructively discharged, even if they resigned, if they met those elements I get to in this presentation, they might have an easier time getting out of their non-compete. So what would I recommend for you as employers watching today? Well, first off, I would recommend respectfully that you analyze your non-compete agreements and your templates. right? Take a look at them. Determine whether they'll still make sense. Will they still be relevant and valid in a post-pandemic work world? For example, if you're hiring remote workers, consider expanding restrictions on future employment in terms of where they might be able to work from. Number two, look at the laws from each state in terms of how they may impact your company's non-compete agreements. So you're a New York-based company, let's say, hypothetically speaking, or New Jersey-based or Connecticut. You're hiring an employee now remotely, and they live and work in California. Well, your non-compete may have been written for your Connecticut employees or your local New York employees, but California has new rules now that can overturn a non-compete for their residents who live there and work there. If they're, for example, in Colorado or in California or Oregon or Illinois have a salary threshold that says if the employee is not making X dollars per year, then a non-compete is an undue hardship. So just take a look at your state laws. And frankly, I recommend respectfully talking to your employment law counsel, right? Find a knowledgeable, experienced employment law attorney to help you through these issues. You can also ask your remote and hybrid employees to confirm their address. Where do they live? Where are they working from? And make sure that if you are going to selectively enforce non-compete agreements, that you prepare a written record about why you're doing so. This is an interesting point here. A lot of companies say, you know what, I'm not going to enforce this non-compete against Joseph because Joseph worked in tech and it's not that competitive, but I am going to enforce a non-compete against Joanna, who worked in this other field of marketing, and they both started and ended the same day and had similar salaries. And Joanna might conclude that she's being unduly penalized or treated disparately, discriminatory basis because of her gender, or maybe she had a history of objecting to unfair labor practices, and she might say this is retaliation, this is the company getting back at me. And whether that's true or false, if that's the perception, it could be grounds for a lawsuit or a claim being filed. And you don't want to spend all this time and money trying to defeat a claim. So make sure you are trying to be uniform with how you enforce non-competes. But if there's a reason why you don't enforce one, document that reason. And some other strategic considerations to have in mind are consider whether revising employment agreements makes sense, and not just the non-competes, but the non-solicitation clauses, and do this with, again, knowledgeable employment law counsel before you terminate your employees or before you change compensation. And remember that with people quitting in larger numbers with the Great Resignation, it's important to do this as soon as possible before you're faced with an employee who resigned and then claim constructive discharge and file for unemployment insurance and try to challenge your non-compete. So speaking of unemployment insurance, perhaps a nice segue into our next issue. And that is the topic of unemployment insurance claims, which have been on the rise since the pandemic. Now, of course, they've been on the rise for a number of reasons, even before the Great Resignation started. Obviously, with people in jobs closing down, companies shuttering their doors, mass layoffs, big people being downsized, furloughed, all that broke loose in 2020. A lot of people were applying for and getting unemployment insurance. But what I'm talking about today is a different phenomenon. I was talking about those people who have resigned in the last, say year or so from their job, or not fired, but they're still filing for unemployment insurance and they're seeking it under a theory of constructive discharge. And they're either claiming that they were in an unsafe environment, a discriminatory environment, or a toxic environment that was just too toxic for them to work in. So even though they quit, for all intents and purposes, they had no other choice, they were fired. And then I'll talk about enforcing unemployment insurance claims, or rather objecting to their enforcement during the Great Resignation, and some action steps for you as employers that you can take. So let's break this down one by one. Unemployment insurance claim, just a very kind of brief background. Many of you might know, but just in case it's something, if you're new in business and you're new to being an employer, you know that when an employee files a claim for unemployment insurance, assuming, of course, that they meet the criteria of having worked for your company for a certain period of time, that they have made a certain amount of money per calendar and per quarter, per calendar year in the quarter rather, they can file if they were fired without, not for cause, not for misconduct, not for job abandonment, and they will let go and they file for unemployment insurance. Very often they will receive it. If an employee's claim is valid, they get up to 26 weeks of unemployment insurance weekly, or less, depending on how long they worked for your company and how much money they made. And most employers won't contest that if that's the case. But when employees leave a job, many of us think, well, if an employee quits, right, that's the end of the story. They're not going to get unemployment insurance. I'm going to protest that. Well, not so fast, right? If they're leaving due to a claim of, right, unsafe working conditions, or if they claim, as I mentioned, intolerable working conditions, different than unsafe, but it could be the same, unlawful discrimination they're suffering, that may qualify them for unemployment insurance benefits. So we need to talk a little bit about what I've used this term now, I think 4 times, constructive discharge, right? Constructive termination. So what do I mean by that? What are the legal elements, like the checkpoints, the criteria, the checkoff for an employee to show they've been constructively discharged? And once we cover that, we'll answer the question, why are these claims rising so much in the last year? Why are we seeing double the number of people claiming the unemployment insurance? Department of Labor will say, this person is leaving, they claim constructive termination. That person left, they claim constructive discharge. So to say what this is about, an employee who claims constructive discharge must produce evidence to demonstrate that, number one, their work conditions will be deemed intolerable when taken as a whole. They're so unpleasant or difficult or debilitating, unpleasant, difficult, or debilitating, such that a reasonable person in that employee's shoes would have felt the need to resign. And that employee, of course, feels it as well. Now, the employee does not have to show intent to drive them out. They don't have to show that the companies conspired, did this on purpose to make them quit. It's enough they show that the employer acted deliberately in creating a toxic environment or condone one. And the conditions that may be considered unreasonable to work through would, as I mentioned before, include unabated or unrepaired, unremedied dangers in the workplace. Around COVID-19, think about all those OSHA violations that companies are being threatened with, discrimination or threats to violence in the workplace. So that's a little bit about the constructive discharge claims. And so what are we finding now when it comes to the pandemic? Well, and then I'll get to action steps, so let's take in a moment. A lot of people who would have otherwise tolerated some very unpleasant conditions in their work, they were at a company, they didn't like it was happening. They felt their boss was a big bully. They felt belittled and abused. When they got a year in quarantine, they worked from home, and they were away from that environment every day, they started to feel what it was like. And a lot of them came back to work, hybrid or remote, or hybrid rather, part remote or in person. And suddenly their tolerance for this got way down, right? And they started to say, you know what, this is intolerable. And with the Great Resignation, we're seeing so many articles written and so many newspapers and reporters talking about this, about employees becoming aware of their rights, employees not tolerating intolerable work conditions. So it's giving employees more, I guess, more boldness, they becoming more bold to challenge conditions that they wouldn't have challenged 5 years ago. And with the advent on social media, people sharing about their work horror stories on TikTok and on Facebook and on Twitter, it's encouraging this sort of almost like a revolution of sorts. So that, I think, explains the increase in constructive discharge claims and people who are claiming it's a toxic work environment. Maybe they're just more of a sensitive basis or a lower threshold to what they would be willing to tolerate. Another issue that comes up is that with COVID-19, there were so many safety issues that workplaces had to be aware of that many companies could not keep up with the vaccine mandates and the changes in that, with the private vaccine mandate options you can have, with safety plans for infectious airborne disease, and with all the different rules around masking and not masking. A lot of companies were getting complaints, and they were firing employees, or the employee would quit, and the employee would say, I had to quit because it was so unsafe. It was not a COVID-19 safe workplace. So for all these reasons, we're seeing a rise in unemployment insurance claims based on constructive discharge. And you as a company could be on the hook for that in terms of liability, not only for their unemployment insurance, but if that constructive discharge claim is tied into a basis of discrimination, the place was too racist for me to work at, for example, or too sexist, or I was being harassed, now you may have also a federal and state and city law discrimination case on your hands. So let's talk about 2 types of action steps. How do you respond to, let's take, for example, a frivolous constructive discharge claim. How does the employee respond to this and protect themselves? That's number one. And the second thing we'll discuss, number two, is it's nice to respond, to be reactive. How do you get proactive and hopefully stave off or try to reduce the number of these claims as they come? So let's talk about responding to an employee's constructive discharge claim. I'm going to take a sip of tea first, if you folks don't mind. I was on a call with the court before, then with a client, so I've been speaking throughout the whole morning. Thank you for bearing with me. So responding to a frivolous constructive discharge claim, number one, gather evidence to make your case. What do I mean by that specifically? Well, gather documents. If the employee says that they had to quit, they were constructively discharged, terminated, what have you, because the workplace was full of toxic bullying, and you as a company asked them to do unlawful things. So look at the record, look at the evidence, right? Gather their attendance records. Do they miss work very often? Were they frequently late? Were they frequently missing work for other reasons? Could that be a telltale sign that something else is going on with them? Number two, look at their resignation letter. Does it state they're concerned about the company or about their treatment? Or is it a very nice, thank you so much, I've loved working here. It's a pleasure being with you all. I hope to come back one day if there's ever a change in my plans. So what are they saying in their resignation letter? And equally important, look at the employee's record and look at communications with that employee before they quit. What are the written protests they have or lack thereof about problems in the workplace? Let me give you a quick example. A client of mine called me up about 9 months ago and said, we had someone who quit and claimed constructive discharge. And I said, oh, well, that's happening a lot these days. Tell me what happened. And they said, well, she claimed we sexually harassed her and we asked her to do illegal things and cooking the books. I said, that sounds terrible. How long was she with you for? They said, a year and a half. I said, okay. I said, in that time, did she ever write any emails, any meetings with you, any texts, any calls, any log, any record of her displeasure with being harassed by whomever she claimed harassed her? Well, no. Did she ever claim any other concern? Did she ever seek out counseling with the HR department? Well, no. Well, what are her documents and communications look like? They were all positive. She got promotion, she got raises, and so it does sort of cast a little bit of skepticism on the person's claim. So look at your documentation, look at letters having to do with employees' reduced hours. Basically, just gather evidence about what you know from witnesses about that person's experience working for your company. So those are some action steps you can take for a frivolous or even a non-frivolous constructive discharge claim. If you want to respond to it, you want to show that you did actually have a safe working workplace. And what evidence do you have to support that theory, that position? So how do you as a company proactive? I'm always a big fan of proactive versus reactive, but I'm human like everyone else. Sometimes I will wait until, that annoying, toothache got to me and I wish I had gone to dentist 3 months earlier. So I think we all do that in some area of our lives, but I'm always encouraging my clients to be proactive when it comes to employment law issues. So how can you, you're out there listening today, you're thinking, well, I'm so glad I have no problems with, I haven't had a single employee complain about constructive discharge. No one's complained about an unsafe workplace. But how can you nonetheless take proactive steps to make sure that most likely doesn't happen? I can't guarantee it, but to make it less likely. So number one, take some steps as best you can to eradicate implicit bias and discrimination in the workplace. What I mean by that, and this again is a frequently an underlying issue in intolerable working conditions of a constructive discharge claim. So hire companies such as MP, right? MP Wired, they do a lot of consulting and trainings for anti-harassment, anti-discrimination. Make sure that your employees at all levels have these trainings and know about implicit bias. Have meetings with your employees to talk about what implicit bias looks like and how you can all be proactive in nipping it in the bud. And also update your protocols, federal, state, local, around safety, like COVID-19, around workplace conditions, and include trainings like MP offers and to reduce the likelihood of toxic workplace bullying or harassment. And also, this is especially important now if you have remote workers or you're so busy keeping up with, the hectic pace of our changing times, and, if you keep your eye off the ball of, let's say, like what's happening with your employees, maybe hire an HR consultant to look in on your employees. Talk to an employment law attorney about other steps you can take to proactively stave off constructive discharge claims, whether they're based on a toxic environment, discrimination, or safety concerns. So we're also seeing, in addition to non-compete challenges, and in addition to like challenges with constructive termination claims, there has been a rise of employment lawsuits, employment discrimination during the Great Resignation. There's been basically a trend, and this is basically post-pandemic employment lawsuits that we litigators expect to see continuing to rise. And so let's talk about this, and let's talk about their impact on the of the Great Resignation on these claims. Okay, so we being attorneys like in this employment law field are seeing an increase in pandemic-related like discrimination claims. Many are workplace disputes wrapped in a COVID-19 context. So, for example, we as employment law attorneys are seeing many more cases of people who argue that like they're disabled. Let's say maybe based on COVID. I think it might even be my next slide here. People who might be say they're disabled and they are requesting a reasonable accommodation request. Maybe with COVID-19, they suffered long haul COVID and they can't shake some symptoms. Now they're disabled and they need to work remotely or to shrink their hours. Or some kind of, it's called a reasonable accommodation request asking for their company. Or some people during the pandemic, what happened? Mental health issues were on the rise. People with, the isolation, the fear of death, the loss of like loved ones, like the constant quarantining. Many people had increases in depression, anxiety, and PTSD, and substance abuse disorders. So when those folks asked for reasonable accommodation requests from their employers, a lot of employers said no. They didn't know that like that person had a right to a reasonable accommodation, or the employer knew the person had a disability, but the accommodation request was so such an undue hardship, it would have broke the bank. It would have cost the company too much money to implement. It would have been a logistical nightmare in operations, or it would have put other employees at risk. So they said, listen, I'm sorry, Fred, I can't let you work remotely because you're the head chef in my restaurant. You can't cook the meals remotely. I can't put you in the basement away from everyone because you have to be in the kitchen. And I can't let you come in if you truly are, say, disabled, where you can't get the vaccine because you might get sick from it, or because it wouldn't help you from getting COVID, because you might now spread COVID to other immunocompromised patrons. So there are just examples that we're seeing a rise in disability-based discrimination cases, with more people disabled from COVID and COVID-related issues, and more people requesting reasonable accommodations. We are also seeing a rise in race discrimination cases. Now, why are we seeing some of this? Well, and also with sexual harassment discrimination cases too. So why the increase in sexual harassment cases? Well, before COVID, a lot of companies were completely in person. And so people were on their best behavior or better behavior because it's human nature when you go into a certain office, at least for most people, not all, and you're around people and you're in the conference room or you're on the elevator and you're dressed up with a shirt and tie, to more often than not be a little more respectful and have more things in check. And if those employees who are discriminatory or harassing didn't know that or didn't care, managers were right there to see what's going on and they can stop things and nip it in the bud. But when the people went remote, many people took it at liberties to inappropriately flirt with their colleagues, or they were lonely, or they were discriminatory, and they were harassing women in their office by, an inappropriate use of the chat box during Zoom, or through texting them, or off the clock calls and asking them for dates. And so there's a lot of increase in harassment virtually. And then with companies being virtual, there was no one really to police and guard these things. So all these contribute to an increase in discrimination claims, an increase in disability-based discrimination claims, and an increase in COVID-19 disability and safety claims. So that's how the Great Resignation and the pandemic are tied into discrimination lawsuits. And the Great Resignation adds to this because people who were leaving who thought, I kind of felt like my employer wasn't too fond of me, maybe because of my, religion or my gender, but I can't quite prove it. And I'm just going to move on or get a different job. Some of those folks are saying, you know what, I'm resigning. I have no other job in sight. And, why not call an employment law attorney on the plaintiff side? Maybe we can leverage my claim discrimination against the company to get a higher severance. Maybe I'll get 6 months, maybe I'll get a year. So we're seeing this, both these issues, COVID-19 pandemic and the Great Resignation, increasing discrimination lawsuits. So that's important for you as a company to know, because you might have an increased chance of getting a letter from an attorney or a complaint filed in court against you. So what are some action steps that you as employees can take to protect yourselves in light of what I just talked about? Well, number one, you can get with an employment lawyer, work with people like myself. I'm happy to talk to anybody on this call afterwards. Work with us and to make sure that you're following the state and city and federal human rights laws around discrimination and abuse. Make sure that you are having trainings about retaliation, and make sure you have good processes in place for things such as progressive discipline and documenting poor performance, and make sure you're firing people the proper way. And HR companies such as MP can also help with some of these trainings around terminations and doing them the correct way. Also important, and I think MP offers this as well, to train your managers and to train your supervisors. Like, how do they spot discrimination in the workplace? How do they spot microaggressions? And they should be looking for more than just the most obvious, horrendous cases of black and white, clear discrimination. Discrimination comes in more forms than but then say a KKK sticker on someone's desk or a horrible racial slur. It comes in many implicit forms too. So really train your supervisors and managers to look out for that so they can nip it in the bud. And when you do, if you do have a complaint filed against you, a grievance, an internal complaint, discrimination or retaliation, or an external one, make sure you get in front of that immediately. When you hear word of it, when the employee comes to you informally or formally, don't wait until the employee quits, claims constructive discharge, and then has a lawyer write a demand letter to you asking you for a year's salary, a severance rather, or files a lawsuit. I always say to people who meet me, they say, "Oh, you're an employment lawyer. That's great. If ever I know someone that's getting sued for employment discrimination or wage and hour violations, I'll give you a call," which is great. But I also like to help people before they get to that crisis mode. So that's just something to keep in mind. And I talked a little bit about ADA accommodations under COVID and disability discrimination suits rising. And so just to maybe give some color and context about that, keep in mind that a failure to accommodate, you as an employer have to accommodate certain employees' physical and psychological and mental disabilities. And there are federal and state and city laws that govern this. There's the ADA, the Americans with Disabilities Act, as amended in 2008, it's called the ADAAA. There's some New York City human rights law and a state law that matches as well, that defines what a disability is. It's very broadly defined by the state and city laws in New York State and New York City. So you have to look at, say, is your employee disabled? Do they have a right to an accommodation request? And is their accommodation request reasonable? Can you grant the request without being financially in the red or in the hole, right? Can you grant the accommodation request without having your operations stalled to a halt? So if you're a Walmart and an employee, who had long haul COVID needs to cut their schedule down to 3 days a week until they get better, it's not undue hardship financially. If you're a mom and pop pharmacy with 3 employees and one wants to go to a part-time or 1/3 of their hours, well, suddenly you lost a third of your workforce almost. So that could be a problem. So look at how the ADA defines a disability and a reasonable accommodation request, and make sure that you document your response to these accommodation requests. If you can't offer a reasonable accommodation, the analysis does not stop with you saying, "No, I can't, goodbye," right? That's the easy way to buy yourself a discrimination lawsuit. What you need to do is engage in a dialogue, a process with your employees. You need to have an interactive process. Talk about, if you can't grant a certain accommodation, "Hey, I'm sorry, Susan, I can't let you work entirely remotely because you are the on-site tech support for our company. you need to help, people like Eric, like when he's in his office, and he can't figure out how to toggle from the Zoom to the Zoom without notes. So you need to be there, maybe in person in that situation. Have another accommodation handy. Ask them, what else can we do to meet your disability and still have you perform your job functions? So my point is, it's an interactive process of responding to a reasonable accommodation request. And you want to document the medical help. You can ask your employees to give you medical documentation, right? If you need to terminate an employee because, let's say, you can't accommodate them, God forbid, like you say, if you run a taxi company and one of your drivers is going blind with cataracts, and that all they can do is drive, they don't do paperwork, they're not available for dispatch, and you might have to let them go. It's sad, but you can't have them driving, and if there's no other job for them to do. But make sure you do all this termination or review with the help of an employment lawyer or HR service companies. I mentioned again, MP. I truly believe this company. I think they're an excellent resource to people. So I'm not shy about putting the name out there. And I would say that in terms of preventing, OSHA-related claims, make sure you train your managers, document your own safety protocols that you're putting into place, and document your safety policies. I recommend going to OSHA or going to your employment law attorney and saying, we must make sure we're OSHA compliant, we're CDC compliant around COVID, and we're complying with the federal, state, and city municipal health guidelines around questions such as vaccines, like in the workplace, or a policy around the infectious airborne disease control. We want to make sure that if another wave of the COVID-19 virus hits, and this wave proves to be, say, resistant to the vaccine, I hope and pray not, but that's not the case. Are you up to date with all the different safety protocols? Because if you are, it becomes harder for somebody to quit and accuse you of having unsafe work conditions, and even harder for them to say that you retaliate against them for objecting to unsafety in the workplace if you can prove to them that you actually had a safe working condition. So make sure you train your managers to know what to look for in terms of safety issues and violations, not just with COVID, but with any kind of physical safety impediment in a workplace. And make sure that when your employees are resigning en masse, that you can address their safety concerns before they bring them up as a basis for a lawsuit or a charge or a complaint. So what are some final recommendations that I have, for employers in light of the Great Resignation? And again, we're seeing so many changes with the workplace these days. Lots of issues come up around workers' compensation and around employment and contracts being enforced and around discrimination. But what are some final recommendations I might recommend as you're going forward? Well, one, again, in the spirit of being proactive, take a look at your work environment. Work with an employment law attorney and an HR consultant and keep your work environment free from bullying, harassment, and hostility. Again, I'm happy to give you guidance on that if you need it. Ensure changes affecting employees are made for legitimate business reasons. You might know in your mind why you are removing someone's title or demoting them or not giving them a raise. But if you're not documenting those legitimate reasons, that person may form a different theory as to why you're doing that. And if that person believes that they and 3 other African-American workers, let's say, were not given promotions because of their race, and you need to make sure that the evidence is clear that that's not the case. And of course, you want to make sure that you talk with your employees prior, this is, I think, an important point, prior to making a significant change to their position, right? If you offer a different position, make sure the responsibilities and the total compensation are comparable to their prior position. And also, if you need to make a unilateral and substantial change, give your employees notice of that change so you can engage in dialogue and reduce the risk of disgruntled employees who feel blindsided and shocked and might feel betrayed and might seek out an employment law attorney that handles plaintiff's cases to try to argue a claim of discrimination even where none exists. So these are just some points. And of course, another point I would mention is to take a look at your employment agreements. Make sure that, I talked about this a little earlier today, you've got employment agreements that have non-compete clauses, and take a look at those clauses. Are they up to date? Are they relevant to your remote workers? Are the timeframes reasonable? Are they keeping in mind what the courts are holding in Second Circuit Court of Appeals cases that are coming out time and again against non-competes? So look at your employment agreements, and maybe you can even have, instead of a non-compete, a trade secret protection contract or an NDA. So then if an employee tries to leave and let's say compete with you, you can sue them if they're taking your trade secrets or if there's a risk of them so doing. So this is some examples of some tips I recommend to proactively get in front of these liability factors and maybe cut down the chance of bad things like these happening to you as an employer in light of the Great Resignation. And with that, I'm happy to open up for Q&A. Have any questions that anyone has about anything I've talked about today, or maybe a related topic that you'd like to talk about? And I'm happy to take a shot at answering your questions. I can, Caitlin, I can pose a couple of Q&As that I've gotten recently from people, but I'm just curious if anyone has any. I'm happy to open the floor for any. And let's see if I can see any in the text box here, chat box rather.
Yeah, I don't think we have any yet. If you want to go over some and see if any come in.
Sure. Okay. Well, I actually would love to give some FAQs that I'm getting, but I think it's great to go back to some of the OSHA things I talked about earlier. The points about OSHA's, the safety protocols to keep. Oh, I'm sorry. I see a hand raised. It says, but I said that somebody, Tracy. I don't see the question, but if there's a question, I'm happy to answer it.
Yeah, and again, just a reminder, all Q&As can be put into the Q&A feature at the bottom of the screen.
Caitlin, would you mind reading the question to me, please? If that's, oh, I think I see it. Never mind. Okay, a question. How successful, I don't know if I should give the name or not. I don't want to embarrass anybody. I'll just, a question. How successful have employees been with these lawsuits, particularly harassment or bias related? That's a good question. It's as attorneys, we rarely give a direct, exact answer. A lot of maybes and it depends, but the answer is, so we're seeing higher, that's a good question, right? I mentioned higher rates of filing. We are seeing the courts come out in favor of employees a lot more on the disability discrimination cases than we used to see in the last year alone. So I think in that sense, there's been a higher success rate about disability discrimination. When I say success rate, what do I mean by that? Well, it could mean that the case survives what's called summary judgment. So because most cases take a long time to get to trial. So, cases that were filed in 2021 or last in November, most likely have not been settled. But if they survive a motion to dismiss or they survive what's called summary judgment, that could be a sign that they're being treated with more deference. So we're seeing some success rate. It's really hard to say exactly. That varies also based on where you're located. So your company, for example, in upstate New York is not seeing the same level of pro-employee courts and investigations from the EEOC as they're seeing down in New York City, or in Manhattan or Brooklyn based, for example. But I would say that they're definitely seeing a rise in the number of these lawsuits. To answer that question more precisely, I'd have to have a remake of this presentation and maybe come back in about 6 months to a year, right? When more cases are decided or settled. But these cases are on the rise, and the courts are looking at them much more seriously. So I hope that answers your question, ma'am. Anybody have? Oh, you're welcome. My pleasure. Okay. Let's see. Was there another question? I think I saw a raised hand, but I don't. Oh, I see another. Okay, a question coming in. Do you see employers using their own doctors for ADA compliance? Good question. I do see some using the company doctors, but more often than not, people will get a diagnosis or an update on their condition from their doctor. And if their doctor gives a valid medical opinion, it's not, in my opinion, a wise strategy to have your doctor to seek to examine that person and give a counter opinion. It could give the appearance like that you're trying to either intimidate them from filing their claim. You know, the doctor's viewpoint, if they don't actually work with that person, they're not their regular physician, coming in could appear biased if ever challenged in court. So I don't necessarily recommend, you know, saying to an employee, well, let's have our doctor examine you. Maybe that's, I see a comment there. A counter opinion, right? Yes, thank you. Yeah, the counter opinion like doesn't always work that, you know, well. What honestly is more important is to look at what they're asking for as an accommodation. Can you do it? Is it too much of a hardship? And can you document that? You know, few people are faking disabilities from a doctor. Usually the ones that say, like, I have a disability without a doctor's note, you have to be suspect of. But most doctors won't go out on a limb with their medical license and say, you know, this person has PTSD, and in fact, they don't. So I hope that answers your question. I think it sort of did. Thank you. I'm glad to have answered. Let's see, any other questions? 1, 2, 3, 4. I see 5 in the chat box and 4 notes. So I must be missing one. Let me see if I can scroll down here. Okay, then do you see another question? I see 4 notes. Maybe I'm missing one. Oh yeah, there it is. Okay, 1, 2, 3. Yes. I saw a notice of a raised hand, but I didn't see the person type a question in the Q&A. Wonder if anybody else has any questions for me. Happy to answer them. You know, one question I'm getting a lot of, or I think one issue I'm getting a lot of questions about is, like, say, you know, if a person says a company has to be, like, to have an employee who, you know, filed a complaint with OSHA or with the Department of Labor around COVID-19 issues or around discrimination, and, you know, that person's a terrible employee and they wanted to fire them before they filed that complaint, and they even suspect the person filed the complaint to try to protect themselves from being fired. Say, you can't fire me, I engage in protected activity. How do you handle those situations? And I find that the timing of the termination can be a key element of whether or not it's viewed as retaliatory. So you want to be careful about putting, like, some time and distance between their protected behavior and the termination if you can. And, you know, continue to build a realistic, valid, truthful record of, like, their poor performance before, during, and after the time when they engaged in that protected activity, being an OSHA complaint or Department of Labor complaint. That's an issue I've seen come up a lot during the pandemic. I think employee complaints are on the rise. Again, a combination of people being less tolerant for conditions that they find dangerous, or having more perhaps desperation and fear around the pandemic and what's been uncovered in the pandemic. So those are some issues I think to cover. And I know, Caitlin, you wanted me to leave time for you to make an announcement. Do I have another minute or two, or what's my time like? I want to make sure.
Yeah, you have a few more minutes.
Okay, great. Well, why don't I just also make sure that any other questions I missed? Anybody else have a Q&A, a question that I can answer for them? Okay, we had a couple already. That's great. I would say that it's also important with non-compete agreements to be careful not to give them to an independent contractor or consultant. This is a big issue I've seen before the pandemic, but with the pandemic and many people going into remote positions and being consultants or contractors, and with many people leaving their jobs, and then the company's left to hire like an independent contracting consultant until they find a replacement, don't give that consultant a non-compete agreement, because remember, non-competes are reserved for employees only. They're reserved for business partners in, let's say, an LLC or a corporation or an LLP. They're reserved for certain top-level employees, but not for freelance contractors. You know, a contractor, the whole theory is that they have control and autonomy over their schedule, their ability to work for others. And so if you have a consulting agreement and you have any language in there that mentions the word non-competition or non-compete, number one, you are potentially invalidating the entire non-compete clause, or even worse, you're invalidating the independent contractor's status and classification. So if they later on claim that they're misclassified and should have been an employee, the Department of Labor will look at that factor as a key factor that tips the scale in favor of that employee's position. And those are really the main issues I've seen like coming up, during the pandemic. I would say that, maybe perhaps in conclusion, if I may take a moment here to take us out after the Q&A, I would just note that the pandemic itself, is creating like many, issues in employment law. It's constantly a changing landscape, a changing field out there. And so it's really important, to recognize that there's been a deep dissatisfaction and marginalization happening with employees, whether it's true or not. That's how they feel, and that's what they're communicating to one another and to their employers. So it's vital to maintain a good dialogue with your employees and a good, strong working environment. As an employer, you need to protect yourself and be updated on the latest federal, state, and city laws. And I can help you with that, and so can each MP, but another employment lawyer counsel, if you're in another state, let's say, and you're tuning in today from Illinois or Florida, that you can find qualified. The key is to find qualified, knowledgeable employment law counsel with an experience with these type of situations and can help guide your company. So with a lot of preparation and with good information and good help, I think we employers, business owners, managers can all get through this time that's very challenging for everybody. With that, I pass the microphone over to you, Caitlin. And again, I want to thank you so much, Caitlin, Samantha, all your staff who helped make this possible and who invited me to speak. I'm really grateful you invited me to talk today. I appreciate having the chance to have the mic. So thank you so much.
Thank you so much, Eric. Lots of valuable information on the Great Resignation. Any questions that were not able to be answered, again, we should be able to reach out in 5 to 7 days. I think that they were all answered, so we are all good to go. The NPHR team is here to help guide your organization on any HR compliance issues. If you would like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. Be sure to join us next week on the same day and time for our webinar on how to reduce legal risk in 2022, COVID vaccine policies, return to work, and more. Visit our website to register and to see the full calendar of upcoming events and available resources. We'll be sending out a recording of today's webinar along with the presentation slides this afternoon. Thanks for joining us and have a terrific day.
And Caitlin, if I may, one more point. So sorry, I forgot to mention. Any questions, you can call me. My number, my office number, dedicated line is 917-930-8684. It's Eric Sarver, 917-930-8684. My website has my email address and contact information at www.sarver.law.com. Thank you.
Thank you so much. Have a great day, everyone.